Hi, everyone. I'm Melissa Pache. I'm the CEO at the Whistler Chamber of Commerce. I'd like to first acknowledge that we are having this virtual meeting on unceded shared traditional territories of the Squamish and Lil'wat Nations. We honor their language, their culture, and their history. With the ever-changing information that's out there, it's important to note that today that we're recording this is actually March 24th, 2020. Our Chamber team will continue to update you as new information is released. We're having obviously some really extraordinary times. Don't have to say that too many times to everybody out there. I think we're all being severely impacted by COVID-19. The Whistler Chamber, along with all chambers across our province and nationally, continue to advocate and collaborate with all levels of government on your behalf. We also want to ensure that we support you, our members, and the broader business community by providing you with the tools and the resources that you need right now to get you through these hard times. So today's webinar, titled COVID-19 Business Support, we're focusing on HR resources and employment law as the first of several episodes that we're going to be hosting over the next few weeks. So in a few moments, you see their faces out there. We'll be hearing from Tess Evans from HR Galaxy. Welcome. I'll introduce you in a moment. And of course, Sholto Shaw. He has the legal lens on, and Sholto's with Race and Company. So before we get started, just to give some context around the conversation around human resources and what the businesses have already gone through and are going through, is to give you a little bit of data that was recently came from the BC Chamber's Mind Reader COVID-19 survey, which generated across the province 8,000 respondents. So just to give you some context for this conversation, 90% of businesses in BC are currently obviously being impacted by COVID-19. 73% of those businesses expect their revenues will drop by 50% or more, with nearly a quarter of them saying revenues will drop by 100%. Half of the respondents say that they will be temporarily shut down in their offices. 64 of the respondents expect to reduce their staff levels by a minimum of 50%, with a quarter of them saying that they will be reducing their staff by 100%. That's pretty significant. So with that being said, I'd first like to introduce you to Tess Evans. Tess has been in Whistler permanently since 2003. Tess puts human, quote unquote, into human resources. Tess has over 20 years of experience in human resources and business operations. Tess is dedicated to streamlining HR systems and documentation so that an organization can be better prepared for continuity and their business. Hugely important these days. Sholto Shaw. Welcome, Sholto, has been a lawyer with Race & Co. for many, many years. I would also like to thank in this moment Race & Company for being the presenting partner for Women of Whistler for so many years now. So I hope that we can get Women of Whistler online in the next few weeks and see if we can get an event there. Since being called to the bar, BC Bar, Sholto has practiced mainly in the areas of real estate, wills and estates, corporate and commercial law. Sholto is an active member of Whistler's volunteer community and has served as a director of the Whistler Chamber of Commerce, the Community Foundation of Whistler, and Aware. So that being said, thank you both for being here today. Tess, let's start with you, or both of you. Making the decision not only to lay off one person, but for so many, an entire company or organization, is not just hard as a business professional, but also on a personal level. Can you shed some light on what you've been hearing from businesses in today's light? And then maybe also shed some light on the difference. The biggest question we're getting right now is the difference between a temporary layoff and a permanent layoff. What's the difference?
Sholto, do you want to do the legal side of that?
Well, a permanent layoff is just that you are permanently being let go. And in that case, an employer is obligated to pay severance to the employee or working notice. You can do also. Typically, employers aren't likely going to do that at this point. But if the option is there, it's a good option. Mm-hmm. Temporary layoff is essentially a break from work, wherein you're entitled to, if you have an employment contract with the employee that allows you to do a temporary layoff, you can lay an employee off for up to 13 weeks out of every 20-week period with the intent that they will be called back to work. at some point. In those cases, if you've got a written employment contract where the employee's already agreed to this, or if the employee agrees at this point to accept a temporary layoff, you don't have to pay them severance. They can immediately go on EI under the new rules, and the expectation is that they'll be back at work within a short period of time.
And that's as a temporary layoff. So they get their 13 weeks out of 20, and then
at that point, you either bring them back to work,
right.
or it's a permanent layoff, in which case they are entitled to severance. The backdrop to all of this is these rules change or are changing sort of on a daily basis, and what was the law yesterday may not be the law tomorrow.
Mm-hmm.
And generally, we're in uncharted waters, and there's really no way of anticipating how this is going to shake out, how judges are going to treat how employers treated their employees during this period. But I think despite all that uncertainty, your obligation, legally and morally, is generally to do what's best for your employee and your remaining employees.
Mm-hmm.
So
the third option that just came down from yesterday's legislative session is there's two things that came out of that, and one is permanent to the Employment Standards Act, and one is an amendment that will be rescinded who knows when. And that one is allowing workers immediately to take unpaid job protected leave if they are unable to work for reasons surrounding the illness, as in COVID itself. So this includes workers who are ill or need to self-isolate, need to care for their child or other dependent, and whose employer is concerned that the employee may expose others to risk. So this is able to leave without putting their job at risk.
Right.
So that, again, just to Sholto's point, is that it's about agreeing what's going to work best.
Right.
And
that sorry.
Go ahead, Sholto.
There have always been similar protections, either under the the Human Rights Act or the Employment Standards Act. And when you're looking at these, at any employment situation, you have to take both into account. But there have been leave provisions during which time the employee, they're allowed to take time off to care for a family member, and the time periods during which you're allowed to be off on unpaid leave while still being an employee and entitled to benefits and lockstep raises and other benefits that your employees are entitled to. Those have always been there. They're now being extended, and the requirements that were in place before in terms of providing doctor's notes, proof that you're sick, proof that a family member is sick, all of these things are, essentially for the short term at least, going out the window.
Right, exactly. And my question, I guess, for employers that are watching this, like some of our larger businesses have an HR department. They've navigated these waters before. The smaller businesses in our community that don't have HR, they're running a coffee shop and they do it all themselves. Where would they be able to go to really understand and navigate that and get that information? Tess, I know that you have some really great resources. Where would they go to?
Well, there's, besides the Employment Standards Act at all, to make sure that employers are doing literally things by the book, is fantastic resource. Don't be afraid to call them. A lot of people get nervous about picking up that phone.
It's a long wait, but it's worth the wait.
It's worth the wait to get the right information right now. And that's my point. It's that a lot of people say to me, I don't want to call because they think immediately they're not complying with something, but that's not the point. You're just getting information and doing it right. You want to definitely take a look at Service Canada website. CRA has so many frequently asked questions pages for so many questions so that you're not waiting on the phone. Highly, highly recommend.
I noticed that they had a really good list of frequently asked questions on there.
There's also, to make it very Canadian content, I've actually been reading a lot of the articles out of the CBC because they are sticking specifically with what are our Canadian federal issues, what package is being passed there, what just happened yesterday in the BC legislature. So sticking with the Canadian content is probably ideal so that there also isn't a lot of white noise out there with other information, but just stick to what we need to know in BC and in Canada.
Yeah, no, that makes sense. Got so many questions that we had sent to us. Sholto, another question for you regarding a temporary layoff. If somebody were to do a temporary layoff for 4 weeks, can they then review that at the end of 4 weeks and continue to extend it up to the period of 13 weeks legally? And then when they get to the end of the 13 weeks, then they either rehire or they permanently lay off that individual. Is that about right?
Yeah, well, you wouldn't rehire them; you would just bring them back to work. But
Okay.
remember, all of these provisions typically will only apply if you have a written employment contract, and many companies don't. I mean, we don't, and you have to have the employee agree. Now, what you have to think about is doing what's best for the employee in the circumstances, doing what's best for you and what's best for your other employees, treating everybody fairly and as reasonably as you possibly can. So there's the side of the employer treating the employee reasonably. I suspect that eventually, whereas employees in the past could rely on the Employment Standards Act because it's prescriptive in the Human Rights Code, I think if things ever came before a tribunal or a judge or some sort of person who's being asked to decide if the employer was reasonable or did the right thing in this case, the judge is going to look at what an employee did in the circumstances also, and
Right.
was it reasonable for an employee, even if they didn't have to strictly under the law, should they have accepted a decrease in their hours or a decrease in their pay in order that the entire company could keep operating. And so in normal times, if an employee was constructively dismissed because you cut their pay by 25%, or reduced their hours, or asked them to do something different that wasn't part of their job description, an employee could leave and essentially obtain severance, the appropriate severance package from the employer.
Right.
In this case, we don't know what's going to happen 6 months from now, a year from now, 2 years from now, when the fallout from this is really felt. So I'd encourage everybody to look at what they can reasonably do to keep their employees working, and I'd encourage employees to be reasonable in accepting changes to their jobs that in a normal economy they wouldn't, and they wouldn't have to.
And that's really going back to those extraordinary circumstances that we're in. 2 weeks ago, I was in Ottawa for a recruitment and retention event on how to bring more people here. So it's quite amazing how quickly it's changed. And on that note, Tess, what is COVID-19 temporary wage subsidy for employers, and how can businesses find out if they qualify? Because I've had that sent to me quite a few times. So just wondering if you have an update on that.
Yeah, the wage subsidy, Ottawa proposed this, it announced last week, and it's set into place for 3 months. So it does have a finite time period to it. It will be equal, and I quote, it will be equal to 10% of total remuneration paid between March 18 and June 20th, up to a maximum of $1,375 per worker, or $25,000 per employer. Now, this isn't something that you actually apply online to. For all employers, this is what you do the math yourself with your payroll to see what your remittance would be, and you scale it back. It does not have to happen in this particular moment in time. It can actually be something that that happens over the next few months. It's just meant to equal out at some point on your payroll with what you've actually sent into the government.
Right. That makes sense. Yeah. Is paying out and using up vacation pay a good solution for some of the employees? We talked about that. Is that
it absolutely can be. And for employers, take this into consideration. If you actually have employees that have significant banked vacation time, meaning it's over a year old banked, technically, legally, you can ask an employee to take that vacation time It could be perfect right now because taking banked vacation is 100% of wages versus 55% of EI. So maybe that works out better for both sides. But it's also an agreed upon decision. Maybe someone does want to take vacation payout or days before their ROE lists them as laid off.
Right. And I think
So,
what I've heard too is because there's been these conversations around, and Sholto, love your comments on this too, is being really open with your employees, being really open and as much as you can, and this is where the legality side comes in, is being proactive with them and giving them an option of a couple of different scenarios. That being said, there's also that legal obligation that we have as employers to ensure that we stay with the law and the way the law is. Is that a recommendation then you would have, Sholto, for employees, is to be open and give employees an opportunity to look at different scenarios? Or do you feel that perhaps the employer needs to make that decision? And as I said, many of the employers around our community have already made these decisions. So it's really now a matter of just reevaluating, I guess, what's been done and making sure that they're in line with the legal side of the choices that were made.
Right. Well, I think, of course, every situation is different. Every employer is different. Every employee is different. There's no sort of blanket rules that would apply to every particular situation. You know, the Employment Standards Act is the sort of basic minimum fallback.
Mm-hmm.
But of course, with any employment situation, the common law applies, the Human Rights Code applies. So there's a variety of legislation. I mean, there's also your employment contract, if you have one, whether it's written or verbal. So there are a few variables in every employer-employee situation. So I'd encourage people, especially where, you know, the stakes are higher in terms of employee salary, the years that they've been with you, to talk to an employment lawyer about your situation, and just to make sure you're getting the right advice, and you're not listening to, you know, necessarily taking everything, you know, that's put on the CBC as gospel. As much as, you know, that information is accurate, generally it might not apply to your situation for whatever reason, because, like I said, there's always variables that you may not have considered that would apply to you or your employee.
Right. Makes a lot of sense. A lot of muddy waters right now, just in terms of navigating. Right. So really appreciate your comments on that. Tess, you wrote a blog for the Chamber where we posted it yesterday on Business This Week. Sorry, on a Biz Alert on Monday. I'm mixing up my Mondays and my Fridays. One of the things that we talked about offline was sharing some tips on keeping your remote workers healthy and engaged. That's a big piece of what we're doing right now, and certainly relates very much to human resources as we are today. Do you have any tips that you'd like to share?
Yeah, it's when everyone refers to staying healthy, it shouldn't just only be about this one virus. Let's stay healthy on so many different levels, including mental health. And just by being healthy, just keep regular healthy habits, even if and although it's very difficult to sleep these days, maybe getting enough sleep, just making sure that we're talking to our teams. If you can, and I don't have solutions for everyone, just ideas, but if you can actually talk to every individual and check in with them, great. Because every individual's questions that they may have for the employer could be completely different from the next employee. Right. So keep things personal for each of your employees. If you can, like I said, you may have a workforce too big to be able to do that, but sending out regular correspondence, even if you don't have all the answers or everything rolling in right now, just important still to check in with people.
Okay.
Having video conferencing like this, there are so many platforms that can bring teams together if people are still working, but working remotely.
Yeah.
Highly recommend on the mental health side is just tapping into there's so many YouTube channels that can help people work out at home now. You can tap into Peloton app, which has everything from meditation to yoga to workouts. So encourage your team to be able to still move around, think, and still correspond with each other.
Yeah, no, that's great advice. Very, very good advice.
I think
Go ahead, Sholto.
on that, I think it's, to follow up on Tess's point, I think it's worth talking to each of your employees, like she said, if you can, because rather than making decisions about laying people off or asking them to work half-time with an EI top-up, whatever the situation may be, you may find that you've got an employee who does not want to work and would much prefer EI at this moment because they've got a couple of kids at home and their spouse may be in some sort of essential service. They're getting paid, they're at work all day. Financially, they're able to go on EI. And from a just managing the household point of view, some of your especially part-time employees may be hoping that you lay them off so that they can stop worrying about trying to work from home or get into work
Balancing
and manage their kids and balancing no daycare anymore typically, but even nannies. There's people can't have nannies because of quarantine or contact. So, it is worth communicating with all your employees because you may find that some people are just hoping to get laid off.
Right. No, that makes sense. A big question, I think that two questions I have for each, Sholto, and certainly Tess pipe into. The first one is, can a business lay off someone who's already on a leave of absence? And then I'll ask the second question after that.
You can. I mean, you can always lay somebody off. The question is, what do you have to pay them as compensation for that layoff? And so, you do have to be a bit careful if somebody's on a medical leave, because it's not just the Employment Standards Act that comes into effect. There's the Human Rights Code, and is it going to cause further medical problems if somebody's been laid off when they're already on leave? But again, with these sort of uncharted waters, you do, to some extent, you do what you have to do for you to survive and your business to survive, but also do as much as you can for your employees.
Yeah. So contact legal advice if you need, if you're really unsure, is contact for sure. Sorry. And then the other, and we're going to wrap up with the last couple of questions, is Sholto again. Can you talk to us about owner-director liability? If I own a company, can I just close my doors and declare bankruptcy? Like, what does that look like? Because again, hearing that through the community every once in a while, it's anecdotal.
Right.
That's a real concern.
It is, and a lot of there will be a lot of that coming along, regardless of the debt relief measures that are in place from governments and banks. There's only so much deferral of debt that owners can manage before they start making money again, and the economy ramps up again. As an owner of a company or a director of a company, you can close your doors, you can declare bankruptcy for the company, but you may personally be on the hook for unpaid wages, unpaid taxes, workers' compensation fees, these sorts of debts that you can't simply just sort of tear up the incorporation papers of your company and say, we're off the hook. I mean,
Right.
The company may not be liable for those debts, but you as the owner of the company and the director of the company may be.
So seek out legal advice before going down that road is the best solution in that case.
Right, because you don't want these debts to follow you personally, because your employees get paid before you do.
Sure.
And so that's something to keep in mind. The other thing to keep in mind for employers and employees, as I said before, there's probably going to be very little resolution of any of these claims for quite some time.
Mm-hmm.
And we don't know what the resolution is going to be. It's really a serious gray area, even at the best of times.
It is.
So again, I'd encourage everybody to be very reasonable. Take advantage as much as you can of government debt deferral, interest-free loans. The BDC's got a good interest-free loan program that you can apply for. The banks are allowing you to defer mortgage payments with very few questions at this point.
Right.
So it's worth looking into all of these other cost-cutting or cost-deferring measures before you take drastic steps of laying people off or even thinking about declaring bankruptcy at this point.
Yeah, it's great advice. It's really good advice. No, thank you for that. And then, Tess, what other than monetary benefits should our community be watching for to roll out in April?
Kind of tagging on to Sholto's point there with this, there's a family that one spouse can stay home and the other still works. There are benefits coming out in April for spouses going home to look after children. So as families, as people, just keep looking again, very specifically at the FAQs for CRA, for Canada, Service Canada, that are going to have, because naturally, all of these programs, the federal aid package, everything can't be rolled out tomorrow. So it's taking them until April to get systems into place. Right. So again, look ahead, because there is financially federal and provincial money that is going to be rolling out now. And it's really great that people know that there's actually information that we can look at and count on. Yeah. So feel good about that.
Yeah, absolutely. Absolutely. And the resources that we talked about are canada.ca on the federal side. There, go to HR, go number 2 HR, and I believe we'll be able to post that link on this video. Go to hr.ca is it's tourism oriented. We are majority tourism in Whistler, so it's a really great resource to go to, literally. And then of course the Whistler Chamber of Commerce, whistlerchamber.com. We're uploading content on a regular basis as we get it from the BC Chamber, Canadian Chamber, or through the government news that we're receiving. So those are areas to go to. Parting words as we close off this first episode on HR. Are there any last bits that you wanted to talk about that you haven't had a chance to say at this moment?
I do, and it surrounds really, although we can't look at the future and know what it looks like, I think it's really important right now to focus on the present for employers, employees, individuals, no matter who you are. We can't change the past. We're not sure about the future, but we know there is one. But focus on living presently. If you're an employer that in the midst of this change has somehow updated procedures, even if it's how to sanitize your counters, if that's your new procedure, lock it in place and know that you can move forward with that. And start to think of those tiny little successes that can happen daily to move momentum forward in what you can control. So we know, like I said, we have more information from the federal government, more from the provincial government. Information's coming, but handle what you can control and start to just build that momentum. Talk to your people, especially the ones that you think are going to be coming back if they're on short-term layoffs, all of those things. Just continue the communication. And just build because you can. And so if they're just trying to say there are tiny successes to still count on every day. And and it's going to build a village to build the village again.
It's going to take a village. I agree. Sholto, to you, any parting comments?
I would just say, take care of each other, take care of your employees and your families. Remember, it's just money. If you have to pay your employee a bit of severance, do it. Try to get the employee to agree with whatever steps you think you need to take. Get their feedback, try to help them, and make sure that you're doing what you think is right by your employee and your remaining employees and yourself, so that when things ramp up again, your reputation as an employer and your goodwill in the community is intact, and you have those former employees wanting to come back to work for you.
Yeah, that's great advice to both of you. And I hope that when we are the three of us back online again, we're going into recovery mode and we're looking at that conversation. So I really hope that happens soon for all of us. I wanted to thank you both again for taking the time out of your really extremely busy days to talk to our business community, our members, and to myself. And take care of each other in your homes, like Sholto was saying, and hope to see you soon, maybe out and about walking carefully. All right, take care, both of you.
Thank you.
We'll chat soon. Thanks again for your time.
Thank you.
Bye.
Thanks, Melissa.
Bye, everyone.
Thanks, Tess. Bye.